Hi listeners, Jason here. We're on the countdown to PHSCon 2025, where we bring some of the leading experts on the topic of psychosocial safety to Sydney for 2 full days on the 19th and 20th of June. With so many great speakers, industry case studies and networking opportunities for the 500 people in attendance, it is the psychosocial safety community event of the year. Highlights will surely include live podcast recordings with Adam Grant and Professor Rob Reiner, international insights from Mary Ann Bainton, Dr. I. David Daniels, Peter Kelly from Canada, the US and UK respectively, as well as entertainment from Jimmy Reese OAM. That's right, we've even got Jimmy Giggle. Early bird pricing is available for a limited time, so get in quick to secure discounted tickets for the conference, pre-conference masterclasses and the VIP dinner. Now, on to this episode.
From Flourish DX, this is the Psych Health and Safety Podcast. With workplace mental health becoming a safety prerogative, this is the source of information on psychological injury prevention and health promotion.
Hi, and welcome to the Psych Health and Safety Podcast. My name is Jason Vanshee, and I'm one of the hosts of the show. The aim of the podcast is to rapidly increase the knowledge and application of psychological health and safety in workplaces worldwide. To help with this, we have regular guests from around the world who are leading the way in this important area. But before I introduce our guest and topic for today, allow me to introduce my co-host, Joelle Mitchell. How are you today, Joelle?
Yeah, doing all right. Had my nephew's 18th birthday party on the weekend.
Mm-hmm.
The dress code was to wear something yellow.
Yeah.
And I don't really have anything yellow.
Yeah, it doesn't really go with your personality.
So I did nail polish instead, and now I have yellow nails, which is a bit off-putting and creepy.
Yeah, it looks like you're malnourished or something.
Yeah, that's what I was thinking. Like, it's all right, I'll do it because it's, the dress code request. But yeah, really need to clean it off because it is kind of nasty looking. Although these were Wicked branded nail polish for so this is the Yellow Brick Road apparently.
Gotcha.
That's the colour that I'm wearing on my nails.
Yeah, well, at least you didn't do your skin, otherwise you would look jaundiced or something.
Yeah, that wouldn't have been great. Yeah.
Yeah. Well, we'll definitely get that covered up. It is freaky.
Yeah. Yeah. No, I just have to actually take the time to clean it off, which is, yeah.
All good.
I think I have nail polish remover at home.
Okay. All right, you heard it here first. We'll check in next episode with Joelle.
I've still got
Did she get the nail polish
chipped
off?
yellow nails or not?
Yeah. All right. We're still. Hey, how many times have you ridden your bike to work so far?
0.
Still 0. Okay. For those of you who are wondering, still 0. We'll check in again. All right. So let's introduce our guest for today. She's one of Australia's leading lawyers working with clients on work health and safety, behavioural investigations and inquests, inquiries and royal commissions. She is a senior fellow at the University of Melbourne Law School and a partner and board member at Maddocks. Welcome back to the podcast, Catherine Dunlop.
Thank you. I'm delighted to be here.
Yeah, it's good to have you back. We actually just re-recorded with Michelle Tuckey. So we're getting around to those people that we had early on in the podcast in our first year and bringing them back. So, really glad to have you back.
I feel honoured.
All right. Well, Catherine, you've done this one before, but what podcast are you listening to at the moment?
I am, apart from yours, of course, I'm listening to The Rest is History. So hanging out with the preteen, just finished something on Franz Ferdinand's assassination, so deeply nerdy. And the other thing I'm doing at the moment, because I'm having a bit of a, insular, not listening to current events, which is very unlike me, I have been rewatching ER, which is on ABC iView, and there's a podcast called Setting the Tone, which goes through every single episode of ER. So I have been immersing myself in that, and it's a very protective factor against real-world events. So that's been good.
Yeah, I think actively disconnecting from real-world events is a legitimate protective action and one that I regularly engage in.
Yeah, I've been enjoying that too. Like, I didn't even know about the wildfires over in California until about a week afterwards. So it was nice.
Yep. And I do enjoy a good rewatch podcast as well.
Yeah, well, this one's great. It's good. They don't spend I always struggle with podcasts where people just every 10 minutes get into some story about their personal life, which lasts for another 5 minutes, and then get back into the talking about the show, and then another 10 minutes of some thing that's happening. There's not too much of that, so it's good.
Yep.
Good.
Yep. Buffy rewatcher. Yep.
You're not even listening to that anymore, though.
I'll get back to it.
Yeah. So what have you been up to since last time we had you on as a guest?
Which is about 3 years ago, I think. Look, super busy at work, like really, think I'm blessed in terms of working with great people, good, busy, lots of interesting issues, growing the team. So one of my colleagues, Dale McQualter, is now a partner in the Maddocks Melbourne office. So work's been busy, teaching at uni, that's been busy as well. Also, in addition to the preteen who listens to history podcasts with me, had a baby. So she's 16 months old now, so she's a hoot. So, yeah, that's been fun. It's an interesting age gap, but it's a delight. So,
well, congratulations on the baby. And the preteen, I guess.
Yeah, that's right. Yeah, no, it's good. They're going to be good together, I think. So, life's good. Counting my blessings.
Wonderful.
Nice. Well, Catherine, last time we had you on, you talked about the High Court case with Zeki Kozarov, and then you were able to come to PHSCon last year and also interview her on stage, which was amazing and hugely impactful. Today, we'd like to talk to you about another very high-profile court case related to psychosocial safety. So this one was also in the Australian High Court, where Vision Australia was found liable for a psychological injury caused by a disciplinary process gone wrong, you could say. Can you give us a summary of the case?
Yeah, sure. So this is an interesting case. It went from the Victorian Supreme Court to the Court of Appeal to the High Court. It's one that generated a lot of interest because of the possibility the High Court might overturn long-standing authority, and they didn't. So to that extent, it's not a particularly controversial case, but I think the learnings from it are more in the facts. So this was one that the facts are important. It was a 17-day hearing in the Supreme Court. The way it was summed up by one of the High Court judges was said to be, an employer botches. Whenever you get a judge saying botches, you pretty well know which way they're going to find. Right? An employer
Spoiler alert.
Exactly. Right. An employer botches its own disciplinary procedures by not informing the employee of key allegations that the employer ultimately considers in deciding whether to terminate the employee's employment, and therefore fails to give the employee an opportunity to respond to those undisclosed allegations or a real opportunity to respond to allegations in fact notified to him. In doing so, the employer breaches terms of the employment contract, and that's very specific to this case. That's not a universal proposition. But then they say the employer unlawfully summarily dismisses the employee. The employee develops a serious psychiatric injury, which is found to be caused by both the botched disciplinary procedure leading to the unlawful termination of the employment and that unlawful termination. So that's the kind of summary of it. As I said, there was lots of attention paid to this case because the case was argued as both a breach of contract and a claim in negligence. It got up on the breach of contract. It did not get up on the claim in negligence. But the employee was awarded $1.7 million in damages, and the evidence was that they were unlikely to work again. So again, a really sad case in relation to the injury to the individual.
Mm.
So what's interesting here, I think, is that disciplinary processes are quite often characterised as reasonable management action carried out in a reasonable way, and often as soon as, it seems like as soon as the disciplinary process is sort of mentioned, it's almost like, oh, well, that's just management action and there's nothing that we can do, and it's kind of almost immediately dismissed or whatever the language might be. So what was it that made this process different?
Yeah, sure. So the starting thing I will say is that the thing that's unusual about this case is that the courts, all of them, found that Vision Australia's discipline policy was incorporated in the contract of employment, and that discipline policy was breached. And that's the reason why damages were awarded in this case. That's not a universal thing. It's certainly been the law for quite some time that you can recover damages for breach of contract when the contract incorporates an EA or policies. But I want to take you through the facts in this one, if you bear with me. I could nerd out in this one for too long, but you can just tell me if I'm going too long. But I think it's a really interesting case in terms of looking at the disciplinary process. So the employee was engaged to set up IT equipment for the visually impaired, commenced work in 2006, signed the contract, which had the wording, which everyone subsequently agreed incorporated the discipline policy. That discipline policy says, when the concern is of a serious nature, a formal disciplinary meeting will occur. Prior to the meeting, an employee will be provided with a letter containing a written outline of the allegations. There's a few little skirmishes before the main incident. So he makes a grievance against another employee, that's resolved. In his performance review, there's a comment there that sometimes people feel they're not listened to, and he seems to kind of think he knows best. But that same document said he'd been a cooperative and helpful team member. Then we have performance reviews, apparently in subsequent years, 2013, 14 and 15, they were not available to the court. And that's relevant because there's this issue about the history of his conduct, right? And we don't have the performance reviews as part of the evidence. In 2014, he makes a complaint against his manager about micromanaging. It's resolved. Later in 2014 and into 2015, he's unwell. He's getting some assistance mental health plan, not a matter for his employer, but kind of background. But then we have these incidents in Bairnsdale in 2015. So in March, he stays at a hotel in rural Victoria. He has a concern about noise in his room. The allegation is that he calls the hotel manager, rings either incessantly or twice, depending on the view of the evidence, asks her to deal with the noise in his room. On his version of events, he got dressed, she came into the room, he pointed the noise, he asked what she was going to do. She said, I can't get up on the roof. On her version of the evidence, he was kind of more physically proximate. She was dressed in her pajamas. It was a difficult thing. It was, I think, either 12:30 or 2:30. And then allegedly the next day he slams his keys down and they fall when he checks out. He then goes on holiday. 2 other employees of Vision Australia go and stay at the same hotel. They hear from the manager about this issue with the employee. His manager then seeks to deal with it by sending an email saying she's been aware for some time his behaviour's deteriorated. She's addressed minor issues with him as they arose. This is something else entirely. He's on annual leave, and I think we need to speak to him. This is gross misconduct and should be addressed appropriately. Then another employee of Vision Australia speaks to the hotel manager. He comes back, he's issued with a stand-down letter with allegations in relation to his conduct in Bairnsdale, and he responds by saying, I vigorously deny any misconduct. I've never behaved in any verbally aggressive way or intimidating manner. I've never raised my voice. I've never used profanities. So we have this big contrast in what's happening. There's then a disciplinary meeting, and it's really interesting when you look at the notes of the disciplinary meeting, because his manager and another talk about him being arrogant, showing no remorse, shocked, no remorse. That's really interesting because the issue here is that the manager had talked about his previous conduct, and the evidence from them and the evidence that the court had was that the real reason for his termination was not really just the incidents in Bairnsdale. It was this history of kind of aggression and behaviour beforehand. So the issue here was not that he behaved badly in this instance, but it was in light of this history, and then saying, well, because he denied it, he wasn't accepting it. Right? So there's that kind of double-edged compounding in relation to the issue here. So like, for example, he demonstrates no awareness that he's aggressive, and that adds to the risk. From his point of view, he says he wasn't aggressive at all. His employment is terminated. There's then a subsequent email that's sent internally within Vision, responding to some union concerns, that says, we will argue that his aggression is serious in itself and contributes to our assessment of ongoing mental health and safety and others and our reputation. It's the latest example in a pattern of aggression that his manager can attest to. We do need to get those previous examples and pattern on record. He suffers really badly. So just to quote from him, his evidence in the Supreme Court was to say, without any exaggeration, it's been catastrophic. There's not been one single aspect of my life that hasn't been destroyed or obliterated. And so we have this issue where he doesn't understand that the employer is looking at a pattern in their mind, a pattern that they don't have recorded. The employer is looking at it and saying, well, we've been told by his manager he's behaved badly. He has denied any of this conduct that fits with this pattern. Right? And so it's a really interesting issue here, which I think we can talk about in terms of what is appropriate process and what's procedurally fair in those circumstances.
Yeah, and so the judgment side of it was very much that lack of procedural fairness, or and I think this is an important learning for any organisation who is going through this type of a disciplinary process, is that you do actually need to give people everything that you're considering in your decision, not just the most recent thing.
Yeah, and there's backwards and forwards on whether you have to provide all the documents and without wanting to give legal advice. You have to give people sufficient material to respond. But if you are intending to look at a pattern of behaviour, or you say that that there's similar facts in the past that make this more likely, you have to put that on the record. You can't simply, as you say, look at the most recent incident that you say occurred and say, well, this is the straw that breaks the camel's back, and so we're relying on that straw. You actually have to provide the material beforehand.
So, I guess what were the claims or key elements of Mr. Elisha's claims against Vision Australia?
Yes, certainly. So he says that there was a breach of contract because of this provision that when there is material of a more serious nature, it needs to be put in writing and then put to him. He said it wasn't put to me, right? And that was ultimately what he was successful in relation to. An interesting side issue, one of the things that was in dispute here was whether or not, if there was a breach of contract, the psychiatric injury was too remote. Most of the judges overall, if you look at the judges across the three courts, say that it was not too remote. One of them said in the High Court, said, well, I find it was too remote because whilst psychiatric injury might be foreseeable for breaching a term of a contract requiring a particular process and a discipline, serious psychiatric injury may not be, which I thought was interesting. There's also a hint in the decision that it was foreseeable because they offered him EAP, which is, I think, again, just a kind of interesting comment. Then we have the negligence part of the decision, and this was something where the employee, through his lawyers, was arguing that there was a duty of care owed in negligence, and that was unsuccessful. In effect, because one of the difficulties that the courts have got to deal with is what they call coherence between the law. So how do you put a duty in there when you've also got duties under OH&S, you've got work cover, you've got general protections, you've got a whole range of other things from a legal perspective. But again, we have this interesting comment from one of the High Court judges that says that in looking at this, it wasn't an OH&S issue because it didn't go to the safe system of work, it went to termination, which many of us would look at and say, no, your safe system of work includes fairness and those sorts of issues as well. And I think our understanding of psychosocial hazards and organisational justice have put it in that realm. But it's just these interesting nuggets here about how members of the court see these issues.
Yeah, you said something earlier there, Catherine, that he was offered EAP, which made the risk of harm foreseeable. Are you saying in this case, offering someone EAP didn't prevent a psychological injury?
Oh, gee, that would never happen. Yes, well, that's right. I don't know whether he took up EAP or not. But I think it's really interesting that you can, and clearly EAP is important, although many people don't take it up, but it can be very valuable. But if you are, as this case, the findings of fact suggest, if you're going through what's called a sham process or a botched process where someone's employment is terminated for reasons that aren't put to them, it can have a catastrophic impact on people.
Yeah. And if we think about the hierarchy of controls, right, that would be right down the very bottom of the hierarchy of controls, and really should be thinking about the safe system of work, which, as you rightly point out, does include organisational justice, procedural fairness. So it's better to look at the processes themselves and what can be modified about the process to prevent harm, rather than relying on the bottom of the hierarchy of controls.
and, we might get to this in talking about concluding comments, but, there are HR managers who I speak to who say, look, sometimes you've just got to get a move on, and like it is the straw that breaks the camel's back, and we just have to act. And I understand that urgency, and I understand that urgency when the managers are saying, I can't have this person in the workplace anymore, they're a risk to anyone. But you can't start that process then. You have to have had a fair process along the way. And if you haven't had a fair process, then you might have to start it in a different place. And I think that's a really key learning out of this. There are people who have read this decision and said, I just disagree with the findings of the court. I can't understand how they got there. But I think the other thing that's really important is that the judge listened to the evidence and found findings of fact in relation to the credibility of the relevant witnesses. And that's an important factor as well. We're reading this in the abstract. The judge is making a decision on the facts. The Court of Appeal reviewed the judge's decision on the facts and said there was nothing that suggested it needed to be overturned. So if you're interested, the judgment of Justice O'Mara at the Supreme Court I think it's 160 pages, so it's a bit, but it's an interesting analysis of the facts involved, because I think, as we can talk about, there are some lessons there in relation to how employers deal with these sorts of matters.
Why would I read 160 pages when I can just get the summary from you, Catherine?
Fabulous.
And so did the three all rule in favour of Mr. Elisha in that case? So the Supreme Court, the appeal, and then finally the High Court? So
the Supreme Court did. At the Court of Appeal, they found that there was not a breach of the contract in the circumstances, so a different decision. But the majority of the High Court found that there was, they found in favour of the employee. One judge found against on this remoteness point, that there was, the damage was too remote, the damage in contract was too remote. Yeah, that seems like a strange conclusion to draw for me, because Well, I mean, one of the other interesting arguments that was put was that the damage to the employee was not a result of the termination, it was a result of involvement in the legal proceedings. And look, any lawyer would say that being involved in legal proceedings is damaging, like it's exhausting and it's hard. That was rejected on the basis that that was not the case, but in any case, that damage was because of the dismissal in the first place. So that was an unsuccessful argument, but an interesting one to have run. Yeah, because surely the damage occurred before the legal proceedings commenced. Yeah, and then to the extent that it might have been compounded, it was a consequence of the fact of the dismissal. Yeah, so there's elements of this that really feel like moral injury kind of mechanism. Maybe not quite. It maybe doesn't have all of the components of that, but there's certainly, I think, a lot of aspects of that present here. Yeah, I think this is one of those interesting cases where HR professionals and safety people will look at it with a different lens, right? Both of which are equally valid, but I think the learnings out of it have to be how do we deal with disciplinary matters in a way that's procedurally fair? How do we have early difficult conversations if we need to have them? And then understanding that if you do not do those things, then there can be health and safety consequences for someone. Yeah, and I think you would be able to quite convincingly argue that having those appropriate disciplinary procedures in place, having them being used correctly, actually contributes to that safe system of work, because you're creating a system that says this is how we're going to manage poor performance, making sure that we are being proactive in addressing it when it emerges, that we are capturing records appropriately so that we can ensure a due process for whoever's involved there. Yeah, I completely agree. And if we move out of the facts of this case for a moment, if you have a situation where you say about an employee that they have a history or a pattern of behaviour of behaving aggressively or inappropriately, or however we want to describe it, then it has to be the case that having those conversations early is better for everyone, right? Whether it leads to a disciplinary consequence, whether it leads to the person leaving the organisation for other reasons, whether it leads to the person improving, I don't think anyone would disagree with the idea that having those conversations, the difficult conversations that can sometimes happen early, is better. It's also fairer. right? And then if you are going to get into a disciplinary process and rely on some of that, you've got the material and you've been procedurally fair. So you've got a fair, documented, defensible process. So I think, for those people who look at this decision and say it's a bit outrageous, it's a bit tough on the employer, the lesson I think has to be that we have to get better at doing those things, without being critical of the employer. In this case, I think, the fact that the court was using words like sham and botched and talking about the real reason being different from the reason that's given, those are pretty stringent criticisms of that process, which ideally could be avoided by leaders. So it's not really an HR problem or an OH&S problem. I mean, it is in the end, but leaders having those conversations. The tap on the shoulder that says, Catherine, the way you've been behaving recently, we need to have a chat about it. There's something going on. All of those sorts of things that we know are good practice.
Yeah. And I wonder if it's the inclusion of the psychological injury here that's throwing people, because from just if this was somebody went to Fair Work Australia and said that they were, unfairly dismissed and Fair Work found that the procedure hadn't been followed by the employer, that would be a fairly unremarkable ruling, right?
It would be, that's right. What's unusual about this is the incorporation of the policy into the contract, which led to the $1.7 million in damages. That will not be common, right? It certainly won't be common for many people who read this decision and then go back and look at their terms of their contract and go, well, we need to make sure that's not the case. So I don't think we will see lots of these cases, but I think there's an element, absolutely, you're right, where this is heightened because of that issue.
Do you need more psych health and safety in your life? Then head over to the Flourish DX Academy for several free on-demand e-learning courses. If you're an internal professional, follow Flourish DX on Eventbrite to register for any of our free fortnightly interactive webinars. Our flagship professional practice program is also exclusively available for internal professionals. The 12-week course blends theory, applied practice, and interaction with other professionals through live lectures and a monthly community of practice session. Find out more about all these learning opportunities or inquire about a bespoke in-house training at the Flourish DX Academy. www.45003.org. Now back to this episode. So you've already touched on it briefly there, but what did the court find then, if we're talking going back to the facts of the case, find in relation to the duty of care to provide a safe system of work?
Yeah. The court said that there was no duty and negligence law, but they did say that there was a requirement to comply with the policy in this case, right? And I think it might be useful just to touch a little bit on the evidence here, because I think when we look at what the evidence was, we understand where they got to, or where the various courts got to. The first thing is that the judge at first instance preferred the evidence of the employee over the hotel manager, and said that the hotel manager had engaged in a process of reconstruction and her accounts got more florid over time, particularly the version given at trial. And she noted that no doubt the hotel manager was annoyed by the plaintiffs and his requests, and later was much more frightened looking back on events, and she was vulnerable, but that didn't mean her evidence should be preferred. So I think we had this contrast compared to the way that the employer just assumed that the evidence of the hotel manager was correct. And there's even evidence from one of the, I think it's from the manager, who said, was asked this question, you said there was no excuse, what did you mean? No excuse for the behaviour. So you'd already decided that the behaviour had taken place? Yes. Before you'd even met with him, before you'd even spoken to the hotel manager, you never spoke to the hotel manager, did you? No. So you never spoke to the hotel manager, you've never spoken to your own employee, and you've decided he's guilty of this behaviour. Is it correct? Based on past performance, yes. Right. Which I think is one of the most interesting parts of the transcript that's pulled down one of the decisions. They also say that the manager gave evidence in an offhand manner and her tone was strikingly callous. Again, that's a bit like botched. We kind of know where this is going to go. And the decision maker, they found, had an evidently incomplete memory of events, and the judge said that was reticent in giving evidence, but it was combined with the tendency to engage in lengthy processes of self-justification. So not comments you want made about you when you're a witness. the reason I raise that is I think there's that evidence there, which is a strong preference, and there's comments about the veracity or otherwise of the employee's evidence. That, along with this sham process, along with this comments about the real reason, along with a comment from the decision maker about saying, well, it's not gossip, it's just a leader talking about the difficulties they've had with someone in circumstances where that's not recorded. You can see how, whilst it's not a finding about a duty of care, you can see why all of those facts together have led the court at first instance and then subsequent courts to conclude that this was a process which was in breach of that policy requirement to provide the employee with the information that you were going to make a decision in relation to.
Yeah, lots of interesting stuff in there.
Yeah. It's a very, it's a sad decision, I'm sure, for absolutely everybody involved in this case. And I can say I've had instances, obviously I'm not involved in this case, but I've had instances where there's a real sense of, as I said, we've got to hurry up and deal with this issue, but it has to be done fairly, right? If you have even if your process is not incorporated in policies, we know what good and best practice looks like, and sometimes we can't undo things both legally and in terms of harm if we don't follow that process.
Yeah. So I guess this case, obviously, when you're thinking about termination being the outcome, that I think people could maybe tie to psychological injury. And so when we think about safe system of work, disciplinary and termination processes, we need to have good procedural fairness around those things, as you've been talking about. Are there any other kind of HR processes that you think should be examined under that lens of, hey, if we do not get this right, if we botch it, this could actually have a psychological injury as a result?
Yeah, I think there's a couple. I think one of the issues that arose in the decision making here that was commented on by the judge at first instance was an all or nothing thinking, that we have to believe either the hotel manager or the employee, and if we don't believe the employee, then the fact that he denies it is more evidence of wrongdoing. And look, many of us have had those situations where two people have a version of events and they're a little bit true and a little bit wrong. And whilst in this case they did prefer the evidence of the judge preferred the evidence of the employee over the hotel manager. Some of what the hotel manager said happened, but the extent and the harm involved may have not been quite right. And so I think that all or nothing thinking is to sometimes be avoided if we can think about the complexities in the way people describe things and the way people perceive things, and it being, I think the judge makes the comment, the hotel manager would have been woken up, it was the middle of the night, she's in her pajamas, she has to go to all of those things also combine into people's memory of things. So I think that is a really interesting observation. I also think that idea that someone won't accept responsibility because they have a different version of events, there's something in that, but I think you can make too much of it as well, right?
Yeah. If we're thinking, though, about HR systems being incorporated into a safe system of work, right, you've got disciplinary processes, you've got termination, but other things like, rewards, so remuneration, promotions, things like that, restructures, they all foreseeably could cause harm to people if those processes aren't followed correctly.
That's right. And we know that that's not just about the individuals involved directly as well. We know if there are restructures happening, that increases the chance of bullying. So organisational change management being a risk factor for other sorts of behaviours that might happen. But we also know that if people perceive poor organisational justice occurring to others, then that's a risk for them too. So it's when we put a safety lens on it, I think we have a much broader perspective than we might have in employment law, which is about whether or not a particular individual is entitled to particular remedies. When we look at it from a safety lens, I think we look at it in a much broader way. And I suspect regulators will as well.
Yeah, and we're already seeing it through, increases in workers' compensation claims that are being awarded for mental injury. And every now and again, I'll have someone bemoan the fact that, there are people who are making these psych injury claims and, sometimes they think that they're unfounded or not warranted. And I'm like, well, have you actually investigated all your HR processes and make sure that they are actually safe and not going to cause psychological injury? And until you've done that, you have to err on the side of the employee because you actually don't have evidence that these things are actually safe.
Yeah, that's right. And you can have a process which is safe in parts but unsafe in other parts too, right? So you actually have to look at the life cycle of the issues involved and make sure it's fair all the way through. Yeah, I mean, let's say the employee in this case did behave badly in the hotel in Bensdale. Well, that's a one-off incident, and we would look at that with a different lens than going into a discussion where we're told it's a pattern of behaviour. So,
Yeah, so I think we'll talk about it now, but it's interesting, I guess, what people can learn from this case and how that might be extrapolated to other aspects of HR processes.
And I think like an important element here is that like no matter how good your performance management process is, no matter how fair and transparent it is, sometimes people are going to still end up with a psychological harm coming out of that, right? Whether that's, developing an anxiety disorder associated with that performance management process would be probably a fairly predictable type of an outcome. And I think typically we would look at a workplace injury as evidence that all reasonable steps had not been taken. But I wonder if that's the case here. Like if you do actually have a performance management process that is, it's published, you've followed that process, it's aligned with good practice, all of those types of things. You can do everything right from that perspective, and somebody can still then develop that anxiety disorder purely through going through that process, which is, on the face of it, a justified process, right?
yeah, I couldn't agree more. I mean, we have to remember that, people come into the workplace with all of their own idiosyncrasies. They may have their own vulnerabilities. They may already be suffering from some mental health condition. Not that that's a reason not to have them in the workplace, clearly, and it's not a reason to discriminate, but that people come with baggage, right, of whatever form. Or they've got things going on in their lives that make them more vulnerable. And you can, as an employee, you can run a scrupulously fair, compassionate process and someone can still be injured. And I think we have to remember that. I mean, one of the saddest cases I was ever involved in was someone who had been through a lot of university and vocational training to be in a particular role. They just weren't performing the role. So they couldn't meet deadlines. They weren't able to do the work with the attention to detail that was required. The employer was meeting with them to try and improve performance, and at one point it was taking their manager like an hour and a half in meetings every week to go through and give feedback. And this went on for a year, and the employee was complaining about micromanaging, bullying, but was just not producing the work. And then would, every time they got enough leave banked up, would take some leave and then would come back to work and would be further and further behind. And ultimately, as the manager said to me, they're in the wrong job. Like, Catherine, they can't do this job. I don't know what to do, but they won't. I can't say that to them in those terms. This is what they've devoted their life to doing. Their sense of identity, or their training, their family expectations are tied to this job, but they are miserable doing the job, and nothing I do seems to be able to help them. Now, in the end, that person left after a period of time, no doubt terribly aggrieved at the employer. The manager was aggrieved because it was taking them in enormous amounts of time and they couldn't see anything that was changing. HR kept saying, is there anything else we can do? There was an attempt to get this person to get some medical advice. This person was resistant, ended up getting some medical advice. The employee didn't like the medical advice. It was one of those classic situations where you could see what was going to happen, but the longer it went on, the more harm it was going to do. Now, all I can hope is that employee ended up somewhere else and is in a job they love. But I don't know. It may be that seriously harmed them for a long period of time. It certainly harmed their manager. And those stories are really, really sad. Right? And, you don't see them all the time, but when you see them, they're profound. And then some people have a very high sense of grievance if they have made a complaint, for example, and it can't be substantiated because there's just not enough evidence, or or it has been substantiated but the other person has left. People have ideas about organisational justice which can't always be satisfied as well, and then they're terribly upset. And again, you can't always manage people's expectations in this space. To be clear, I'm not being critical of any of these people, right? But it's just because I'm often advising employers, they say there's nothing I can do to fix this, and I kind of say it's probably not. You can't. But getting back to the purpose of this conversation, it doesn't mean we shouldn't try, right? We should always be looking at what we can do. And, even the manager in this, or the decision maker in this case, conceded that the process wasn't as good as it could have been. So let's make it as good as it can be and see whether or not that reduces the risk of harm.
Yeah, and so that leads us on to the next question, which is what lessons should employers learn from this case?
So I think many would say the dangers of incorporating policy in your agreements. That's, I think, a very legal view. But, I without commenting on this policy in particular, I see lots of policies that are overly prescriptive and that employers are not going to be able to comply with. We will have a preliminary investigation within 48 hours and we will give you a result of such and such by this time, and we will interview everyone in a trauma-informed way by an independent person in this, completely ignoring the fact that people might not want to participate in the process, might be on sick leave, all of those sorts of things. So I think having policies that are give rise to a right to damages can be difficult because many policies cannot be followed. Right? And every week I look at a policy and say, I wouldn't be putting that in there if I were you. Right? But we still have these underlying obligations to deal with risks to people's health and safety and to have a procedurally fair process. So it has to be defensible. And I think the big lesson out of this is what can we learn? We can learn that if a manager has a concern about an employee, raise it with them. Get better at that conversation. And I think this is a lesson generally that's not just about the way someone conducts themselves, but we've got to get better at the early conversation, the tap on the shoulder, whether it's the how are you conversation, whether it's the how is your workload conversation, or whether it's the that comment before was a little overly aggressive, let's talk about a different way to do it. And then where you need to follow that up with a formal process, you do it and you have a record of it. And then if the person's behaviour doesn't change and we have that straw that breaks the camel's back, you have a defensible process. But also just generally that early tap on the shoulder. So often I speak to leaders and managers who say we're scared of ever raising an issue because we don't want to be accused of bullying. And that is a really sad indictment, I think, on the way that we are educating our leaders and managers in Australia if people aren't having those conversations, because we are missing out on so much in terms of safety and performance. So I'm a little evangelical about this, can you tell? And I just think, we promote people to managers without ever telling them how to have a difficult conversation. And then they don't, and then a process falls over, and then we're critical of it. We've just got to get better at it.
Yeah, definitely a lot around that, who do we choose to put into those leadership roles, and actually what are our selection criteria for those roles, particularly when we're doing internal promotions, right? And how do we make sure that we are actually getting people in who have the existing capability to do that people leadership, which is very different to like technical leadership. And then what do we need to do from an upskilling perspective to make sure that they can actually implement that HR policy, which is part of their job, to implement those policies for their team. So are they trained in what those policies actually contain? Do they know how to do those things, and who can they draw on for help, right? Is HR actually there and capable of providing coaching and support for leaders or not? And if not, who can they draw on?
That's right. And do they know that's an inherent part of the job, and are they prepared for it? Because how often do we see the burden of good psychosocial risk management within an organisation fall on middle management leaders, right? It's pushed down to that level along with everything else they're doing, and question whether they're given the skills, the support, they've got the aptitude, they even understood they would ever have to do this. So, yeah, completely agree.
Yeah, we do see that a lot. I think a lot of the time Like we see clients who want to just come in and start by training their frontline leaders in psychosocial risk management, and it's kind of having that conversation with them around, well, what internal processes do you have that leaders can actually draw on to help them with that? Like, do you have procedures or processes that tell them what to do when they've identified a psychosocial hazard? Where can they record or report that? How do they escalate it? What are the things that are within their control to manage? And, you know, what is their escalation pathway, and all of those types of things. And often those processes aren't in place. And so, you know, when we are asked to nevertheless deliver that training in absence of all of those processes, you know, it always ends up with leaders feeling, quite vulnerable and really unsure of actually what their roles and responsibilities are within that business.
Yeah, I can absolutely see that. And you will have had this experience as well, where you have a leader who's got a difficult problem and they go to someone in HR and they've got that sage HR leader, who says, okay, I think the way we deal with this, and then like every word that comes out of their mouth is like a diamond and they have this beautifully clear process through it. But the HR leaders also need the capacity to have that conversation. And so when you start a process of having more difficult conversations, or I'm assuming going through risk assessment processes, are people prepared to commit to that time that's required, because it will potentially take more time as well. So I don't know whether you see that, but I certainly see there are times where people have the skills and they have the interest, but they're so there hasn't been planning for the time and the energy that this is going to take.
Yeah, that's definitely a big part of it, because working through any type of a performance management process, even if it is that kind of proactive and helping to build somebody's performance up to where it needs to be, it is really time consuming.
We also sometimes see it's the opposite, right? So it's not just having the hard conversation when someone's performance isn't, up to par, like doing that early, as you've talked about, the tap on the shoulder, but sometimes being too overeager to make accommodations. I had an example given to me just recently where, a leader had this person was clearly going through some of those issues back at home, wasn't work related, and so he made some accommodations for this person because she just couldn't keep up with the normal pace of work. A few weeks later, still wasn't doing any better, made further accommodations. Again, a little bit later on, further accommodations, to the point where she just wasn't being productive. It was no use her even being at work because they'd taken that much off her. So there's also that other issue, right, where people are maybe overtuned to, I want to really make sure I look after the mental health of this employee, but then it's to the detriment of everyone else in that person's team, because they end up having to pick up the extra slack because the other person's no longer contributing.
Yeah, I completely agree. I have some very sage advice from a colleague of mine who always talks to clients about this, about you, and it's such an interesting way of describing it. You separate the person from the role. So this is the role they're required to do. This is their personal circumstances with whatever else is going on, and we want to accommodate that. So maybe they can't do the role for a period, so we give them an alternative role. But is that going to be permanent? Because at some point they need to go back to doing that role. Right? And if there's a disconnect between the person and the role, either we make accommodations long term, right? We try and improve someone's performance to the extent that that's relevant, or we might have to have a conversation that says you can't perform the inherent requirements of the role, which is that example I gave you earlier of the person who just couldn't do the role. Sometimes I think people struggle with that because they are making the accommodations for the person. They're talking about the person, they're very person-centred, but people are employed to do a role. And it's either that role or another role or no role. And if you separate those out, then when people start talking about, you need to do this, you need to do that, that's not fair, this is the issue. No, that's the role. This is what we're doing. We want to support you, but you have a role to do. That kind of thinking of separating it can be quite useful. And it also requires the role to be very clear, both in terms of the output, but also those things like culture, performance, behaviour. I mean, we haven't talked about that here, but the tap on the shoulder works when people understand what the expectations are. So you also need that to be part of the role description too.
Yeah, and I'd like to see it where, people are given accommodations, but, at some point in time, you have to have that discussion, right? Like, is this the right role for you? But I also see that, leaders again aren't trained to know when to escalate, and is that to HR, is it to an occupational health provider or something like that to get the person on a treatment plan, if that's required.
That's right. And the conversation that says we can change the role for a period of time, but I can't do this indefinitely. So we have some avenues we can look at that point of view time, but let's look at what we can do now to try and make this work.
Yeah. So, there's so much in terms of what Joelle was saying before as well. You need to have a think about all these processes that support the poor, middle managers before you just ask them to manage people better.
Yeah, that's right. That's right. And, most people are doing their best, right? Most people have, but, a lot of people have got more on their plate now than they have had. And I think, I'm a huge supporter of flexible work, but I think it does require more management attention. I think that is something we've got to factor in. There are a whole lot of things that have changed in the workplace over the last 5 years or so, maybe even 10 years if we talk about people's tenure in particular workplaces being shorter. There's lots of things that are happening that make the job of middle managers much harder.
Yeah. Well, Catherine, it's been another fascinating dissection of another, high-profile legal case with you. I can't remember because I think it was 2021 that we had you on. So I don't remember how you answered this question last time, but we ask it every podcast episode. So what are your hopes for the future of workplace mental health?
Well, I think there's two. One, I'm constantly saying to people, have the conversations early, the tap on the shoulder early, which we've talked about. I think that's really important. And I think if we could get better at that, we would solve many issues. But as we've talked about, there are various barriers to that. But I think that would be enormously valuable. I think as well, we talk a lot, or people talk a lot about leadership in workplace mental health. That's not just about standing up on Are You OK Day and making a speech saying it's okay to put your hand up or whatever. I think it's about what do we do from a risk assessment point of view to try and get to a situation where we understand things and we can predict them and we act to prevent them. And I know you're doing great work in this area, and there are many people who are doing great work in this area, but I think we are still far too reactive. We wait for the triggers and the green shoots of a problem, or maybe they're not green shoots, they're brown shoots, I don't know. But we don't get to, I can see this, it's going to be a problem. I've thought about a plan ahead of time. So I would love to see more of that.
Yeah, I think that's great advice, and it all comes down to that risk-based approach, right? You don't need to wait until you've had an issue like Vision Australia to foresee that you may have an issue and actually start thinking ahead of time, what could we do to actually prevent these things from happening?
All right, last question today, Catherine. What are your words of advice for listeners who want to work in the field of psych health and safety?
I don't know how I answered this last time either. I think all I can say is keep up with thinking and developments. This is an area where there's wonderful people who have really great insights to share. So however you decide to engage with that, I think it will pay off in spades. We know now more than we did a few years ago. We probably had some of the theory then, but we've seen more of it in practice. There's such a community of people who want to share ideas and information. So reach out and become part of it.
Great.
And advice about attending PHSCon in June?
Oh, well,
Catherine?
that is an absolute must, I've got to say. I'm not the only person who said that last year's was, if not one of the best conference that they've attended for many years, if ever. So I found it enormously valuable last year. I thought the calibre of speakers was fantastic. Leading those aside who chaired sessions, I'm not including myself in that, but because that would just sound really up myself. But I thought it was really, really valuable. I don't say that lightly either. I'm not being paid to say this for anyone who's listening, but I thought it was fantastic. So I'm really looking forward to it this year. The problem is you've set such a high standard, you've got to meet it again. So no pressure, but pressure.
Yeah,
we don't want the sequel syndrome, right?
Yeah, second album syndrome.
No, this would be like 22 Jump Street or Hot Tub Time Machine 2. It will hold up to the original. So.
Oh yes, Hot Tub Time Machine 2, that beloved classic.
Or Empire Strikes Back. But
or Back to the Future or The Dark Knight. There's lots of there's plenty of good sequels.
I just wouldn't have thought about Hot Tub Time Machine 2 in that list of excellent sequels.
Watch it before you judge.
No.
Okay. Well, Catherine, it's been fantastic having you on again. We're looking forward to seeing you in person in June, and hopefully lots of other community members as well. Again, we just really appreciate you being part of the community and being so willing to share without us having to pay your hourly rate.
Indeed, fabulous. Thanks, guys.
Thanks, Catherine. All right, listeners, that brings us to the end of this episode. Remember, we do record these over video when we have these conversations with our guests, and you can catch all of those videos on the Flourish DX YouTube channel. We also take snippets, the best of the best, and they end up on the Flourish DX LinkedIn page. So go over there if you maybe more time poor. While you're on LinkedIn, feel free to reach out to Joelle, myself, or Catherine if you want to continue the conversation. But that's it for today. We'll catch you next episode.
You've been listening to the Psych Health and Safety Podcast. To stay up to date with the latest on psychological injury prevention, follow Flourish DX on LinkedIn and subscribe to the Psych Health and Safety Podcast at www.psychealthandsafety.com.